ignored by no less an instrument than the Constitution itself. Section 179(4) of the Constitution requires that there be national legislation which guarantees the independence of the prosecuting authority. That legislation is the NPA Act. At the center of any functioning constitutional democracy is a well-functioning criminal justice system. If you subvert the criminal justice system, you subvert the rule of law and constitutional democracy itself. Unsurprisingly, Section 32(1)(b) of the NPA Act proscribes improper interference with the performance of prosecutorial duties. The present litigation is rooted in a sorry state that has engulfed the NPA for a number of years. As the High Court aptly put it, since September 2007, the recent history at the NPA, quote, has been one of paralyzing instability, close quote. Within only 9 months of Mr. Nxasana's appointment, former President Zuma commenced a process calculated to remove Mr. Nxasana from office. The former president did this in a manner that kept mutating. It was first a stick, then a carrot, a stick once more, and eventually a carrot. First, there was a notice to commence an inquiry into Mr. Nxasana's fitness for office with a threat of suspension. Mr. Nxasana brought an urgent High Court application seeking particularity on allegations on which the former president's decision to institute the inquiry was pegged to enable him to make representations on why he should not be suspended. The former president changed tack and suggested that there be mediation. When there was no progress on the mediation, former President Zuma appointed the person that was to chair the inquiry, and the stage was set for the inquiry to proceed. But parallel with this, Mr. Hali, the former president's legal advisor, obviously acting with the former president's sanction, made a promise that Mr. Nxasana would be paid a settlement amount. Over time, that amount increased progressively. Throughout, Mr. Nxasana unequivocally stated that he did not wish to resign and that he considered himself fit for office. Of course, he did indicate that he would resign if he was paid the full salary for the remainder of his term of office. Settlement was reached on 14 May 2015 after signature of a settlement agreement by Mr. Nxasana, the former president, and the minister. Mr. Nxasana would relinquish his position as NDPP and receive 17.3 million rand as a settlement figure. In the event, Mr. Nxasana was paid an amount of 10,240,767 rand 47 cents. The rest was retained by the state for income tax. He vacated office. In an application brought before the High Court, Corruption Watch and FUL challenged the validity of the manner in which Mr. Nxasana vacated office. In a later application, CASAC challenged the validity of Section 12(4) and 6 of the NPA Act. The applications, which were consolidated, were successful, hence the confirmation application before us. An application by Mr. Nxasana for condonation of the late filing of an answering affidavit in the two applications was dismissed with costs. He appeals against that order. And Advocate Abraham's and the NPA also appeal against the order invalidating the appointment of Advocate Abrahams. In terms of Section 12(1) of the NPA Act, an NDPP holds office for a non-renewable term of 10 years, but must vacate office on attaining the age of 65. Section 12(4) of the same Act provides for the possibility of extension upon the attainment of age 65. An NDPP may voluntarily vacate office before her or his term is up in terms of Section 12(8) of the NPA Act. This section empowers the President to allow an NDPP to vacate office on account of ill health or for any other reason which the President deems sufficient. Mr. Nxasana disavowed any invocation by him of Section 12(8) of the NPA Act to voluntarily vacate office. In this court, none of the parties disputed that Mr. Nxasana had not vacated office in terms of Section 12(8). Advocate Abrahams and the NPA argued that it was legally competent for an NDPP to vacate office voluntarily otherwise than in terms of Section 12(8). That Mr. Nxasana had thus voluntarily and validly vacated office outside of the provisions of Section 12(8). That when he vacated office, a vacancy was created, and that Advocate Abrahams was then validly appointed into that vacancy. This raises the question whether, based on this argument, it is competent for an NDPP to leave office voluntarily outside of the provisions of Section 12(8). In a judgment penned by me, concurred in by Kachalia A.J., Dlodlo A.J., Froneman J., Goliath A.J., Hampepe J., and Theron J., I take the view that it is not necessary to answer this question. The facts I summarized earlier point to one thing and one thing only. Former President Zuma was bent on getting rid of Mr. Nxasana by whatever means he could muster. It should be borne in mind that this entire saga started because former President Zuma overtly made all and sundry believe that he had a basis for holding a view that Mr. Nxasana was no longer fit for office. It must have been a matter of relative ease then to pursue the inquiry instead of offering Mr. Nxasana what by all accounts was an extremely huge sum of money. Crucially, in its judgment, the High Court noted that before it, the parties were agreed that 17.3 million rand far exceeded what Mr. Nxasana would have been entitled to had he vacated office in terms of Section 12(8) of the NPA Act. Instead of settling for so huge an amount, why did the former president not simply pursue the inquiry? Did he not believe that the evidence that had motivated him to come up with the idea of an inquiry was sufficiently cogent? If so, why did he not just abandon the inquiry and leave Mr. Nxasana in office? After all, he was exercising powers as president and not involved in a personal dispute which he could settle as he pleased. It is difficult to comprehend why he would have settled on so huge an amount and from public coffers to boot. The inference is inescapable that he was effectively buying Mr. Nxasana out of office. In my book, conduct of that nature compromises the independence of the office of NDPP. It conduces to the removal of, quote-unquote, troublesome or otherwise unwanted NDPPs through buying them out of office by offering them obscenely huge amounts of money. Although I deliberately eschew deciding the question whether an NDPP may vacate office outside of the provisions of Section 12(8) of the NPA Act, this much I do want to say. It can never be that vacating office outside of these provisions would ever entitle an NDPP to more benefits than those set out in Section 12.8. Section 12.8 is specific on the benefits. They are the usual public service benefits. The problem with benefits that are not kept by the Section 12.8 limit is that they give rise to the real possibility of NDPPs being bought out of office. That compromises the independence of the office of NDPP. Whatever we are to make of the full import of Section 12.8, the manner of voluntary vacation of office should never undermine the constitutional imperative of the independence of the NDPP. Consequently, the manner in which Mr. Nxasana vacated office is in consonant with the constitutionally required independence of the office of NDPP and is thus invalid. What then of the appointment of Advocate Abrahams? This appointment was consequential upon the constitutionally invalid vacation of office by Mr. Nxasana. The Supreme Court of Appeal judgments in Odekral and Seal make plain that where a consequential act following upon invalid conduct could be valid only as a result of the factual existence, not legal validity, of the earlier act, the consequential act would be valid only for so long as the earlier act had not been set aside. This court affirmed this principle in the case of Kerland. Now that I've held that the manner in which Mr. Nxasana vacated office is constitutionally invalid, it follows that the appointment of Advocate Abrahams is also constitutionally invalid. I next deal with the constitutional validity of Section 12.4 and 6 of the NPA Act. Section 12.4 empowers the President to extend the term of office of an NDPP or a deputy NDPP, which must ordinarily come to an end at age 65, beyond that age, but not for a period which exceeds or periods which in the aggregate exceed 2 years, provided that an NDPP's term of office shall not exceed 10 years. The President's power to extend an NDPP's term of office undermines the independence of the office. In Helen Suzman Foundation, this court held that the possibility of renewal may render the holder of the relevant office pliable and receptive to the preferences of the one who holds the discretionary power to renew or not to renew. Coming to Section 12.6, two aspects that make the President's power to suspend particularly egregious are the facts that she or he may suspend with or without pay and for an indefinite period. This tool is susceptible to abuse. It may be invoked to cow and render compliant an NDPP or deputy NDPP. The prospect of not earning an income may fill many with dread and apprehension. The possibility of this enduring indefinitely exacerbates the situation. All this undermines the independence and integrity of the offices of NDPP and deputy NDPP and renders Section 12.6 invalid. Moving to the appeal by Mr. Nxasana against the High Court's refusal to condone the late filing of his answering affidavit, that affidavit was inordinately out of time. His explanation for the lateness was that filing at the time he did was pragmatic. This is so because, given the delay caused by former President Zuma's failure to comply with Rule 53, Mr. Nxasana might have had to file more than one affidavit, and his desire was to provide only a single affidavit. The High Court refused condonation for two reasons. The first was that the explanation for the delay was not persuasive. I agree. The second was that, quote, it is generally accepted that when evidence is presented so late in proceedings, there is the danger of it having been tailored to fit a particular position, close quote. On this, the High Court overlooked the specific facts of this case. To put it bluntly, it misdirected itself on the facts. On all material issues, the content of the affidavit had support elsewhere in the High Court record. This minimizes, if not eliminates, the danger identified by the High Court. Thus, one of the pillars on which the High Court refused condonation cannot stand. That entitles us to interfere with that court's exercise of discretion in refusing condonation. Although the explanation for the delay is weak, Mr. Nxasana is strong on the merits of what the answering affidavit was meant to achieve. That is, to counter former President Zuma's version. Another factor that counts in Mr. Nxasana's favor is that although he delayed in filing his own affidavit, he expended time and effort towards the compilation of a proper Rule 53 record and was thus of great assistance not only to Corruption Watch and FUL, but to the court as well. Also, based on the possible relief that may be granted and the likely bases for it, a lot is at stake in this matter. That tilts the scales towards giving a hearing to all disputants, including Mr. Nxasana. Lastly, I'm not aware of prejudice that was suffered by any party as a result of the late filing of the answering affidavit, and none was suggested. Mr. Nxasana's appeal against the refusal of condonation must thus succeed. I must now deal with the appropriate remedy. According to our decision in Steenkamp, the automatic effect of the declaration that the vacation of office by Mr. Nxasana was constitutionally invalid is that ordinarily Mr. Nxasana is entitled to resume office as the NDPP. Must we allow that to happen? Section 1721B of the Constitution gives us wide remedial powers when deciding constitutional matters. If we exercise that power in a manner that denies Mr. Nxasana the opportunity to return to office in accordance with the Steenkamp principle, that will effectively be going against an extant legal principle. But in Mhlophe, we held that if it is just and equitable not to follow the strictures of statutory provisions that have not been invalidated, Section 1721B does empower us not to. In Black Sash, we cautioned that exercising our remedial jurisdiction in a manner that perpetuates non-compliance with an extant legal position must be done only in exceptional circumstances. The question is whether there are exceptional circumstances in the present case. I say there are. For years, there has been instability in the office of NDPP. With a court challenge to Mr. Nxasana's vacation of office and to the appointment of Advocate Abrahams, that instability persists to this day. The sooner it is brought to an end, the better. An order that has the effect of prolonging the instability cannot be just and equitable. Allowing Mr. Nxasana to return to office would have that effect. That is so because the President might well decide to institute an inquiry into his fitness for office for having taken part in the improper settlement agreement. To all this, we must add the fact that Mr. Nxasana is not free of blame in the manner in which he vacated office. Although he strongly protested his fitness for office, he was prepared to vacate if the payout was right. I sympathize with him for the undue pressure he was subjected to, but I do not think that is the reaction expected of the holder of so high an office the holder of which, if she or he is truly independent, is required to display utmost fortitude and resilience. Former President Zuma appointed Advocate Abrahams following his unlawful removal of Mr. Nxasana. That removal was an abuse of power. Advocate Abrahams is a beneficiary of that abuse of power. It matters not that he may have been unaware of the abuse of power. The rule of law dictates that the office of NDPP be cleansed of all the ills that have plagued it for the past few years. It would therefore not be just and equitable to retain Advocate Abrahams, as this would not vindicate the rule of law. A minority judgment written by my colleague Jafta J and concurred in by Petse AJ agrees with my judgment, with the exception of my conclusion that Mr. Nxasana should not be allowed to return to office. In this regard, the minority judgment says that if we accept that the termination of Mr. Nxasana's appointment and the settlement agreement were unlawful, the consequence of setting them aside is an automatic restoration of the original position, which is the return of Mr. Nxasana to office. The minority judgment further elaborates that in the present matter, there is nothing exceptional or extraordinary that warrants the exercise of remedial power to prevent Mr. Nxasana from returning to office. On the minority's view, Mr. Nxasana's return will not cause a constitutional or national crisis. On the contrary, his return to office does not mean that he is fit to continue in office. If his involvement in the conclusion of the settlement agreement renders him unfit, it will be open to the President to invoke Section 12(6) of the NPA Act and establish an inquiry to determine his fitness. If found unsuitable, Parliament would be involved in his removal. More importantly, preventing Mr. Nxasana from returning to office without pronouncing on the validity of his employment contract will not only be unfair to him, but will also create considerable uncertainty on the party's rights and interests. The minority judgment then concludes that to require Mr. Nxasana to pay back the money in circumstances where he is not allowed to go back to office cannot be fair to him. Allowing him to go back to his job would also meet the objects of the Constitution and the rule of law. In the result, the following order is made. 1. The appeal of Mr. Mxolisi Sandile Oliver Nxasana is upheld with no order as to costs, and Mr. Nxasana's explanatory affidavit is admitted. 2. The costs order by the High Court of South Africa, Gauteng Division, Pretoria, against Mr. Nxasana is set aside. 3. The appeal of Advocate Shaun Abraham and the National Prosecuting Authority is dismissed with costs, including the costs of 2 counsel. 4. The declaration by the High Court that the settlement agreement dated 14 May 2015 concluded by former President Jacob Gedleyihlekisa Zuma, the Minister of Justice and Correctional Services, and Mr. Nxasana, in terms of which Mr. Nxasana's incumbency as the National Director of Public Prosecutions was terminated, is constitutionally invalid, is confirmed. The declaration by the High Court that the termination of the appointment of Mr. Nxasana as NDPP is constitutionally invalid is confirmed. The declaration by the High Court that the decision to authorize payment to Mr. Nxasana of an amount of 17,357,233 rand in terms of the settlement agreement is invalid is confirmed. The declaration by the High Court that the appointment of Advocate Abrahams as NDPP is invalid is confirmed. The declaration by the High Court that Section 12.4 of the National Prosecuting Authority Act 32 of 1998 is constitutionally invalid is confirmed. 9. The declaration by the High Court that Section 12.6 of the National Prosecuting Authority Act is constitutionally invalid is confirmed only to the extent that the section permits the suspension by the President of an NDPP and Deputy NDPP for an indefinite period and without pay. 10. The declaration of constitutional invalidity contained in paragraph 9 is suspended for 18 months to afford Parliament an opportunity to correct the constitutional defect. 11. During the period of suspension, A section 12.6, lowercase a, uppercase a, will be inserted after section 12.6a, and it will read, quote, the period from the time the President suspends the National Director or a Deputy National Director to the time she or he decides whether or not to remove the National Director or Deputy National Director shall not exceed 6 months, close quote. B, Section 12.6e will read, with insertions and deletions reflected with square brackets, quote, the National Director or Deputy National Director provisionally suspended from office shall receive for the duration of such suspension her or his full salary. 12. Should Parliament fail to correct the defect referred to in paragraph 9 within the period of suspension, the interim relief contained in paragraph 11 will become final. 13. Decisions taken and acts performed by Advocate Abrahams in his official capacity will not be invalid by reason only of the declaration of invalidity contained in paragraph 7. 14. Mr. Nxasana is ordered to repay forthwith to the state the sum of 10,240,767 rand 47 cents. 15. The President is directed to appoint an NDPP within 90 days of the date of this order. 16. The President, the Minister of Justice and Correctional Services, and the National Prosecuting Authority are ordered to pay all costs in this court that are additional to the costs referred to in paragraph 3. Such costs to include the costs of 2 counsel. I hand down the judgment. Court adjourns.